of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner, and good morning, Ms. Lawrence and Mr. Hubble. We are thankful that you could join us today for a live streaming oral argument. Judge Bennett and Judge McBrayer and I appreciate your participation. Please recognize that we will conduct today's hearing in the same fashion as we would if all of us were in the courtroom together. Each of you have 15 minutes, and I understand that the appellant has already reserved up to 5 minutes of that for your argument. And unless there are any other comments or announcements, we will ask Mr. Hibner to call the case.
In re estate of Johnny Baxter Vaughn, Jr.
All right, please proceed.
Good morning, and may it please the court. My name is Jake Hubble, and I represent the appellant in this case, Cheryl Vaughn. Lawrence Sands is also attorney of record for Ms. Vaughn. Mr. Sands handled the case at the trial court level, filed the brief in the matter, but due to some health problems, he didn't feel that he could be present for the oral argument today, so he asked me to enter an appearance as co-counsel for purposes of handling the oral argument.
Well, very good. We're pleased to have you with us, and we hope Mr. Sands feels better soon.
Thank you. I'd like to reserve 3 minutes of my time for rebuttal.
Very good. The clock has been programmed accordingly.
Thank you. We framed this case as a matter of two issues. The first being whether the trial court erred in not allowing the appellant, who's the administrator of the case, credit for funeral expenses for the decedent. The second, funeral expenses and the administrative expenses of the estate, which were the filing fee and the fee for posting a bond. The second issue is whether the court erred in not allowing the appellant credit from the proceeds of the estate for expenses to maintain and preserve the real property of the decedent. The appellant is the administrator of the estate and was the wife of the decedent. The decedent had 3 children from a prior relationship. It is an intestate estate, so the appellant would take a 1/3 interest in the estate. The remaining interest would be divided among the 3 children. What the case really comes down to is whether, for both of these issues, whether the appellant was required to file a claim against the estate for these various expenses. Our position and our argument is that the appellant was not required to file a claim against the estate as a general creditor would, but rather could file on a final settlement, request credit and an allowance for these expenses, which she did. So it's our position she would be entitled to the expenses out of the proceeds of the estate. The trial court initially found that she would be entitled to those credits and set a hearing to determine whether the fees and expenses were reasonable. The opposing counsel filed a motion to offer or amend, and the trial court reversed its position and ruled that the administrator was a creditor of the estate and would be required to file a claim against the estate, which she did not do. She never filed a claim, and we don't dispute that. Our position is essentially that she's not required to file a claim under 30-2-307, which is the claim statute, because the expenses that she's incurred were not debts of the decedent that were incurred during his lifetime. She paid approximately $24,000 for funeral expense, which obviously was after the death of the decedent. It was prior to her appointment as administrator. However, we think that she's, as the administrator of the estate, that's an expense of the estate as opposed to a debt of the decedent, and that she'd be allowed credit for that.
Mr. Hubble, which expenses did she incur prior to the opening of the estate?
Well, she incurred the funeral expense, which is the main expense. That's the big one. So she certainly incurred that one.
Okay.
And she paid out of her pocket, I think, the filing fee and the fee for the bond, prior to opening the estate in order to get the estate open.
Well, they were incurred with the filing of the petition for letters of administration. Okay.
That's correct. Some of the, and this may be a correction to the brief that Mr. Sands filed, some of the expenses, it appears from my review on the house, appear to be incurred prior to the opening of the estate.
Okay.
There was a roof replacement and some additional expenses. However, our argument regarding those expenses would be that upon the death of the decedent, the administrator and the decedent's children became owners of the property as tenants in common, and that upon a sale of the property, that she would be entitled to any expenses for maintenance and improvement under Parker v. Lambert, which was a partition case that set out what co-tenants were entitled to credit for during a partition.
Did your client and the 3 children have a written agreement regarding the sale of the real estate and the recoupment of expenses?
There was a court order that was entered on June the 8th of 2018, agreeing to sell the real estate and agreeing to some expenses that the administrator would be entitled to incur. It does appear from the record that some of the expenses she incurred relative to the real estate were prior to that court order being entered. So
did the court order make reference then to the roofing expense or no?
The court order did not make specific reference to the roofing expense.
But it did to other expenses.
It did to some cosmetic repairs, to the removal of a deck, and really, other than the specific removal of the deck, it referenced just generally cosmetic repairs, but wasn't real specific as to repairs.
And it's your client position that the roofing expenses were necessary to preserve the real estate in order to sell it?
That's correct.
Okay.
And that she would be entitled to contribution from the other owners for that expense.
Typically, real estate passes outside of the administration of an estate. But if there are insufficient funds to pay the debts of the debtor, or if the parties agree, then the real estate can be brought into the estate. Did this order, June 8 order, say the real estate was going to be part of the estate, or did it just say it can be sold, you can incur some expenses, and you can recoup them?
It really never specified and never said that the real estate was part of the estate. There was never a motion filed alleging that the estate was insolvent, and there was not a finding by the court of insolvency or that there was insufficient assets. There was just a motion to sell real property and an agreement that the property would be sold under those.
Did the order say that your client could sell the property in her capacity as the administrator, or did it not address that either?
I do not recall.
Okay, well, I'll look at it. I'm sorry I haven't looked at it that closely already, but I will. Thank you.
Thank you. Sorry, I can't answer that.
It's all right.
At any rate, we think those expenses outside of the context of the estate, we likened it in our brief to more of a partition sale, where under the partition law, she'd be entitled to credit for those. I think the brief does list the entire amount of the expenses that she incurred, mortgage payments, insurance, and I do think that she would have been responsible for 1/3 of those on her own. So I think that there may need to be some adjustment made to that upon a review of the brief as I sit here today. That certainly the other parties wouldn't be responsible for the entire thing. It should be prorated according to their ownership interest. The bigger expense in getting back to the funeral is the bigger expense that I wanted to look at, which was $24,000. And I think that an administrator, even though she did incur this expense prior to being appointed administrator, I think there's certainly a public policy and some argument and some case law out there that we want to encourage people to take care of the dead and to have a dignified and normal funeral. And according to Wiles Brothers and Company versus Gwynn, which is an old case. It's a 1918 case that said it's the law in this state that in the absence of any direction in a will, an executor or administrator has the right to use his discretion in incurring funeral expenses as long as the amount is reasonable. I anticipate that opposing counsel will argue that the claims statute abrogates that case and would require a claim to be filed. I don't think the claims statute did that. The claims statute addresses filing a claim. The claims not necessarily, but it doesn't abrogate the fact that an administrator could contract for funeral expenses and should be entitled to those upon a settlement of the estate.
And your position is the claims requirement pertains to debts incurred by the decedent, obviously prior to death, not expenses and obligations incurred on his or his estate's behalf after his death.
That's correct. That's correct. And under TCA 30-2-606, which deals with accounting by the administrator, says that the court shall credit the accounting party with a reasonable compensation for services and with disbursements supported by lawful vouchers. So I think that statute regarding accountings and what the administrator is entitled to credit for, I think the funeral expense should be covered in that. It's certainly a priority expense under the statute, which is more akin to me to the administrative expenses, attorney fees, than it is to a general creditor.
Now, speaking of the attorney's fees, the trial court made an important finding that the administrator's services and the legal fees incurred by the administrator did not inure to the benefit of the estate. That's an important finding. So how do you overcome that?
Well, respectfully, I think the trial court was wrong. I think services of the attorney did inure to the benefit of the estate. I would have to concede that perhaps some of his attorney fees may not have benefited the estate as a whole, where there was, an exempt petition for exempt property that was filed late, and there were some things that he did that I think were more in line with being for the administrator personally. So I would agree that some of those attorney fees may not be allowable as charges against the estate, but I think some of them are, and the trial court should have differentiated those and allowed some of the attorney fees. Yes.
Thank you.
Thank you, Judge.
Very good. We'll hear from you on rebuttal, Ms. Lawrence.
Hi, good morning, Your Honors. Lindsay Lawrence for the appellees. It is our position, Your Honors, that the Tennessee State Legislature in 2017 amended Tennessee Code Annotated 30-2-307 to add subsection F, which specifically contemplated the situation that we are in here today. I think that this is almost a matter of first impression. After the amendment to 30-2-307 in 2017, I could not find any case law that specifically addresses the situation in which we are in now. But it is the appellee's position that the administrator was required to comply with the claims statute in order to receive any sort of right to retainer pursuant to that statute, in addition to 30-2-306 and 313. What opposing counsel fails to mention to this court is that the expenses that she would like to receive, or that she alleges that she incurred and should be borne by the estate, were handed to me in a handwritten fashion. I don't know who hand wrote those, on October 1st, 2018 in open court. They were not accompanied by a motion, and further, any attorney's fees that they requested were never accompanied by a motion. There was never a motion for attorney's fees in this, although the judge at the trial level did make the specific finding that Mr. Sands' representation did not incur a specific benefit to the estate. So first, we contend that they were required to comply with the claims statute in order to receive reimbursement on certain items. In addition to that, we did enter an agreed order in, I think, June or July of 2018 regarding the reimbursement of certain expenses. But what's also been failed to proffer to you at this time is that the roof expenses specifically were something that was incurred prior to the death of the decedent. and the unverified pieces of paper that I received regarding some quotes of the roof itself were both from 2015 and 2017, prior to the death of the decedent. In addition to that, I agree that we contemplated that there would be certain expenses that the administrator would receive from selling the real property. However, we never heard any sort of testimony on that. And that's another fact that I think should be brought to this court's attention, is that both the requests for expenses were unverified. They were handwritten and handed to me. There was later a petition to approve an accounting and distribution of assets, which was later amended by the appellant. And neither that petition nor the amended petition contained any sort of verification by the administrator herself. And then upon, to go back to the initial order that came down when the trial court found that she was not a creditor within the meaning of the statute, prior to my motion to alter or amend, the trial court still required that she needed to come in and verify those expenses. Opposing counsel, I think, said that the trial court found that she was entitled, but I don't think that there was any specific finding in that order from October of 2018 that she was entitled to expenses. Only that order stated that she was not a creditor within the meaning of the statute, and that a subsequent hearing would have to be held in order to determine whether those were reasonable and necessary. That hearing never occurred, and then later my motion to alter or amend was granted, in which the trial court then found that she was a creditor within the meaning of 30-2-307. And after that, there was never any testimony from the appellant. She failed to appear at the final hearing. The morning of the final hearing, her attorney asked for a continuance based on some sort of medical issue that she alleged that she had had for some time. The court gave us a 2-hour break in order for her to submit something that supported her allegation that she could not physically be there, but she was unable to do that during that time. And so the trial court then entered the final order in this matter. So,
Ms. Lawrence, if I may step back a moment, you mentioned that the administrator never filed a motion for her fees or never filed a motion for her expenses, and that someone just handed you, she or someone handed you papers in the courtroom. How did the issue get before the court if she didn't file a motion?
well, in October of 2018, we were having a number of hearings. There had been an untimely petition for exempt property, an untimely petition for an elective share. And so the court was kind of hearing everything that was before the court at that time. I had made objections regarding the lack of a motion to accompany both of those things. But I think at the October hearing, they determined that she wasn't a creditor within the, or that she was not a creditor, and that she would be entitled to some of those expenses. And then at the final hearings thereafter, it was brought up, and counsel for the appellant had filed this kind of collective petition to approve the accounting and distribution of the assets. And in that petition had included requests for the reimbursement and request for the attorney's fees. So I believe that through that petition that he filed and the amended petition thereafter, that would be how the court discussed them or made findings or orders on them.
Okay, so the formal request for reimbursement of expenses and for fees was within the petition for approve the accounting and the distribution of funds.
Yes, Your Honor, but both the petition and the amended petition were not verified by the appellant.
But then after that, there was never an evidentiary hearing at which the administrator or anyone else testified as to the reasonableness of any of these requested expenses and fees.
Correct, Your Honor. We had a number of procedural motions between October 2018 and the final hearing in July of 2019, but no, she never appeared and proffered any sort of testimony on an evidentiary basis for those expenses.
Thank you.
So to return back to, it's the appellee's position that she was required to file a claim within the meaning of 30-2-307F, and that's exactly what was contemplated by the legislature when it made that amendment in 2017. But even if the court were to find that she's not a creditor within the meaning of the statute, even though it's our contention that she is, and that's exactly what was contemplated, again, we go back to these expenses were handed to me at one point in October of 2018. There was a petition filed thereafter. There was an amended petition filed after that, none of which were verified, and that there was never any sort of evidentiary hearing where she proffered any sort of testimony on these expenses. So we find that this court should affirm the findings of the trial court, first because she was a creditor within the meaning of the statute, and if you were to not find that she was a creditor within the meaning of the statute, that these were unverified expenses in which we never heard any actual testimony on. Again, the roof itself was something that we would proffer happened prior to the death of the decedent, which would not be appropriate here. I find that
If there was never a hearing of evidentiary hearing, how do we know when the roofing expenses were incurred?
that would be based on the hearsay documents that I received that accompanied this, what was handed to me in October of 2018, and the petition and the amended petition. They were attached to some sort of exhibit. They weren't entered into evidence per se, but that would just be based on the face of it.
But the information you have is based upon the bills or a writing that says these roofing expenses were incurred in 2015 and 2017, which was before his death.
Yes, these were quotes that we received that either the decedent himself or the administrator had received from some sort of roofing company. That's what accompanied both the handwritten thing I received and then the petition and the amended petition thereafter.
So they were quotes and not invoices?
I think that they were quotes. I mean, a quote / invoice. I don't know that we ever saw anything that specifically showed a check that was written, but I know that they were a quote that was received and dated in 2015 and 2017 prior to the death of the decedent.
So we're just, I guess based on that, and it seems, I don't blame you for making this assumption, you're assuming that it was quoted and the work proceeded pre-death, but it's conceivable that it was quoted and then the administratrix decided after the death to do the work. So that's conceivable too, I guess, right?
It is most definitely conceivable. I don't know that there's anything in the record that would show one way or the other. I just, from recollection, it's my understanding that the roof was replaced prior to the death of the decedent.
We just don't know for sure from proof in the record.
Correct, because there was no testimony that was ever proffered by the administrator, and none of those were ever entered into exhibits in any sort of way. I guess the appellees find it interesting that there's now some sort of partition argument that this would be one of the first times that we have heard this within the brief of the appellant. I don't know that this is the appropriate, I guess, test, the 5-part test to consider at this time, because again, it's the first time that they've offered this to this court, and it certainly was not offered to the trial court by any means. We do not think that appellant contends in their argument that the presentation of accounts that was done within the petition to approve the accounting and distribution of assets and the amended petition as well somehow circumvents her requirements under 30-2-307, in addition to filing some sort of pleading that would get those expenses before the court or get her attorney's fees before the court. We don't find that any sort of quote presentation of accounts would circumvent her responsibilities here. Again, it's our contention that what was happening here was what exactly was contemplated by the legislature in its amendment to 30-2-307, subsection F. And there's no evidence in the record which would support an award of unverified debts, some of which, again, we contend occurred before the death of the decedent, when the appellant failed to assemble something into a claim, either based on the statute itself, if you find that she is a creditor within the meaning of 30-2-307, or within some sort of pleading that would be verified. Even if she's not a creditor within the meaning of the estate, we would still contend that she's required to verify her expenses in some sort of way, and or to provide testimony that would verify them within the court context. In addition,
Ms. Lawrence,
yes.
although it's a modest amount of money, how can the court deny the administrator's request to recover the filing fee and costs associated with initiating the opening of the estate?
Well, Your Honor, I think that that's what the statute contemplates, is that 30-2-307 requires that she file this within 12 months and give notice to all the residuary beneficiaries if she wants some sort of return on her expense.
But some estates stay open for years and the estate is not closed and the probate court retains jurisdiction over it, and the probate court has a responsibility to review and approve the accounting. So you can't even request reimbursement for the filing fees, at least nobody does, until it's time to do the final accounting.
It was my understanding.
What I hear you saying is that if the estate stays open for more than a year, then whoever opened the estate is out of money.
Well, Your Honor, I think that any claim could be filed within the 12 months of the decedent's death, and that claim could be held in abeyance, or it could be, it could be amended prior to the final distribution of this. So she could put
what about the court costs that might be incurred for hearings and motions and petitions and subpoenas 13 months later, 18 months later, 24 months later? Are you saying nobody can seek to recover that?
No, Your Honor, I think that they exactly can seek to recover that if that's an expense that they want to be borne. I think that you would file a claim. If they have to do it
within 12 months of death, the 12 months is already run before the expense is even incurred.
Correct. I think that you would file a claim and then you would amend that claim and have that heard prior to the final distribution or at the final hearing itself.
You would amend the claim to ask for something that hadn't even occurred.
Well, I think, Judge, you could file a claim within the 12 months of the decedent's death, stating that you are entitled to certain reimbursements of expenses. And then prior to the final hearing, you could amend that claim to include all expenses that have incurred at that time, including any attorney's fees to be borne by the estate.
Okay, thank you.
So appellant argues in his brief pursuant to TCA 31-2-103 that the funeral expense and the administration expenses should be reasonable and chargeable back to the estate, and that upon qualifying that the personal representative is vested with the personal property and has the ability to do that. I would just show that these were not paid by the personal property of the estate itself. These are paid personally, and so when she wants to seek personal reimbursement, she's required to comply with the claim statute.
All right, thank you, Ms. Lawrence. Mr. Hubble? Be sure to unmute.
That would help.
That's a public service that we provide for free.
I appreciate that. A couple of things that I wanted to point out about 30-2-307 and the amendment there too that's been discussed. That amendment, first of all, I don't think there's anything in that amendment that added section F to that statute that requires specifically a personal representative to file a claim regarding funeral or administrative expenses. To the extent that it does, I would also point out that that amendment was effective July 1st of 2017, which was after the death of the decedent and after the estate in this case was opened. The estate was pending at that time, but I would argue that that amendment specifically is not doesn't apply to this case, but even if it does, I still don't think it requires a claim to be filed for funeral or administrative expenses.
So the petition had already been filed before this section F went into effect? It
had, and okay. The estate had been opened. I don't know the exact date. I think it was April of 2017.
Okay, we'll find it.
I know it was before this statute was effective. As far as opposing counsel mentioned the roofing expenses, And my recollection is that there was one proposal with a dollar amount that reflected a payment and then an existing balance, and that proposal was after the death of the decedent. There was an additional document in the record that does have a proposal that has a 2015 date as it appears. It's a photocopy, and in the absence of an evidentiary hearing, I'm not sure whether that date is correct, whether it's a 5 that could have looked like an 8, but I'm not speculating on that. But I think that's the problem with there being no evidentiary hearing. And the court initially set an evidentiary hearing to determine the reasonableness of the expenses, but then upon opposing counsel's motion to alter or amend, the court found that the administrator was a creditor and would have had to file a claim to even get credit for these expenses. So there never was an evidentiary hearing to determine that. What we would ask the court to do is to find that the administrator was not required to file a claim for any of these expenses, remand the case back to the court to have an evidentiary hearing to determine the reasonableness of the expenses. And, you know, the other heirs can certainly argue that those expenses are not reasonable, or that for whatever reason she shouldn't be entitled to them. But I don't think she had to file a claim, and I think the case should be remanded back for a hearing to determine whether the expenses were reasonable or not.
All right. Thank you, Mr. Hubble and Ms. Lawrence, for your arguments. We appreciate them very much, and we will take this matter under advisement. Mr. Hibner?
This honorable court is now in recess until 10 a.m.